Good afternoon to you all joining us this beautiful afternoon. I see quite a number of you are logging on. You're welcome to this wonderful session. Welcome to this chat room. Please feel free as you log in, feel right at home, share a link with a friend and tell a friend that our session is on right about now. We'll be streaming live on our YouTube channel at East Africa Law Society. And we're also live on this Zoom platform. And if you're watching us from our YouTube channel, please allow me to say welcome to our YouTube channel at East Africa Law Society. We are thrilled to host you. Please subscribe, hit that button, and share that link with a friend. Said that we get to learn together. We're here to learn and share knowledge with one another. So as we settle in this afternoon, we are very excited, to host you all. Like I said on Tuesday, this session this afternoon is one of the sessions that you do not want to miss for anything in this world. And as such, please permit me begin with a rhetorical question, or rather a question. So imagine it is the year 2045, and there's a devastating flood that has displaced thousands of families across an East African city. Businesses have collapsed, public infrastructure has been destroyed, insurance claims are mounting, investors are demanding answers, a case is filed, and it's not against the weather, it's not against nature, it's not against God, it's not against a corporation, it's not against even a ministry, but it's against directors who signed off on environmental disclosures. It's against a government department that was negligent in exercising its mandate. It's against that negligent operation that sat when it should have done something. And of course, definitely against you, the lawyers, professionals who advised them. And sitting in that courtroom is me, a lawyer, is you, a lawyer, being asked a question that would have sounded unimaginable a generation ago. And that question would be, when did your client know about climate risk? And what did they do about it? That question there. And ladies and gentlemen, that future is not approaching. That future is here with us. Around the world, like we all know, climate change is rapidly evolving from an environmental concern into a legal risk. We all know that our courts are being asked to determine responsibility for climate harm. Regulators are imposing new disclosure obligations. Investors are constantly demanding for accountability, and communities are turning to litigation. And then the lawyers find themselves at the center of some of the most consequential questions of our time. And these questions is what has always made the legal profession adapt to those great societal shifts. We've adapted into globalization, to the digital revolution, we've adapted into AI, and we are now being called to adapt to something that is larger, the legal consequences of a changing planet, a planet that we sat and watched change right before our eyes. Today's session, friends, is just not about environment. It's about that liability. It's about governance. It's about risk. And it's about the future of our practice, where we find ourselves in today. Now, to guide us through this very critical conversation, we're privileged to be led by an accomplished legal practitioner whose deep insight and experience has earned him respect with his clientele, with colleagues and the wider legal community. Our moderator is a partner at MNW and Advocates LLP in the busy city of Nairobi, Kenya. He brings to this discussion the depth, perspective, and analytical rigor that is required to navigate this complex discussion in this field of legal practice. Ladies and gentlemen, please join me in welcoming my friend, my brother, Mr. Mokua Manyara. Mr. Manyara, the floor is all yours. You have us for the next 2 hours. Blow us away, and we are ready to learn from our esteemed panel, who, by the way, is drawn across the East African region. So you'll be hearing different perspectives of different people from different placements, but speaking the same language. So over to you, Mr. Manyara.
Thank you, my brother Gabriel. I am not as a good public speaker as you, but I'll try and do the Lord's job. So today we are having a webinar themed the climate change as a legal risk, what East Africa lawyers need to know about environmental liability, climate litigation, and the growing duty to act. Amongst us are panelists drawn from different countries within the East Africa region. We have representation from South Sudan. I see Mr. Bola has joined. We have representation from Kenya, from Uganda, and from Burundi. So we have a rich heritage to share our insights from across the regions. And as you know, climate change and environmental governance really doesn't respect borders. So we will hear from each of them. They will each have 15 minutes to make a presentation, after which we will have a session for question and answer. Participants are encouraged to either use the chat platform or the Q&A section on the chat. And your questions will be answered either orally or through the same platform. Also, at the end of the presentations, you can raise your hand where you will be identified and you can raise your question orally. These slides will also be shared at the end of the webinar. And welcome. So we will start with the first panel speaker, that is Dr. Martin Opondo Olo, whom I have the pleasure of introducing this afternoon. Most of us have seen him on TV, so today we are seeing him live in our computers. Dr. Opondo Olo is an advocate, scholar, and seasoned governance practitioner who currently serves as the Dean School of Law, Daystar University. He holds a PhD in strategic leadership from Pan-African Christian University, an LLM in public law, specializing in human rights, governance, and democracy, and an LLB from the University of Nairobi. He's a practitioner for more than 15 years. He has taught corporate governance at the School of Law, and his counsel has shaped public policy at the highest levels. I'm informed that between 2015 and 2017, he served as the chief legal advisor to 3 different cabinet secretaries across the ministries of education, lands, and where he was instrumental in drafting Kenya's land laws, including the Community Land Bill and the Physical Planning Bill. So he has done extensive work in this field of environmental governance, and I'm pleased to invite him to give us his brief presentation for only 15 minutes. Ladies and gentlemen, please join me in welcoming Dr. Martin Opondo Olo. Daktari, the floor is yours.
Asante sana. Thank you very much, Mr. Mokua Manyara. And colleagues, ladies and gentlemen, good afternoon. Yes, we have time to manage and we have also conversations to advance. So I am going to put on my timer so that I can be in order. Having said that, I want to say that exactly 7 days ago, it was a Thursday last week, I was in a lower court somewhere in the coast. I'll try not to disclose so much. And my clients, a mother, her sons, and some of the community members have been going through a criminal trial for the last 5 years. And I have had the opportunity to work on that criminal trials. There were about 7 or 8 criminal trials against them. Then last week, we had the final matters adjudicated. and my clients were found guilty of assault and fined fairly heavily, and the magistrate's sentiments were like this: that whether you are an environmental activist, that does not give you an excuse to picket and to obstruct and to assault. And so the key word is whether you're an environmental activist, that does not give you the freedom to picket and the freedom to assault others. My reading of it was that environmental issues were not that serious, for which no much action can be taken. And if you do, in fact, some of the charges that had been leveled against them was that they were behaving in a manner likely to cause a breach of the peace. Why? Because they were picketing and so on. Thankfully, that part of the law had just been struck out about a month or two ago out of a High Court decision. So that part collapsed, and several other, charges collapsed, except these two charges around assault and so on. Long and short of it is that these are environmental activists fighting against pollution around a certain area where they live. And what the agent or what the company that's doing this or that's causing this environmental pollution has done is to criminalize the activities and to trump up charges against them, to the extent that they have been hanging around the mother and the son and so on, have been hanging around courts for so long. I happen to have been doing this on a pro bono basis, having actually gotten this task out of an assignment that we had been working on as LSK in the coastal part of the country. And so I've been saddled with that case for a while. What am I saying? Are we in a situation where environmental issues are receiving that kind of limelight they should be receiving? Are we making enough of jurisprudence around it or not? My sense is, I have been asked to say whether a state can be held, I've been asked to answer, can a state be held liable, legally liable, if it fails to protect its people from climate shocks? Now, my response to this is that increasingly the answer to this question is yes, because government liability and legal obligations, especially around the East African region, is now something that is gaining ground, and there is jurisprudence around it that is supporting the fact that there is some progression, that there's some progress that is being seen around issues of litigation. So that when we want to understand this, we need to explore both the two trunks, the framework, the international covenants, and the domestic statutory duties are around the East Africa. And what I want to say right from the outset is that yes, the international framework may not be very obligating as such. Whether you're looking at Paris agreements, yes, there Africa is being seen as particularly maybe on the end of climate finance or technological transfer. But then later on, as we come down to regional instruments, the reality is that whereas we can talk about being differentiated, rather having a situation where you have the differentiated responsibilities and respective capabilities, there is reason to come down with legal instruments such as the African Charter on Human and People's Rights, and then we begin to see state obligations. In fact, the explicit nature around which the African Charter on Human and People's Rights, the explicit nature in which it is framed, makes people a centerpiece, and therefore makes it necessary to see that the government or the regional bodies are demanding regional governments to guarantee the right to satisfactory environmental framework that is favorable to generally the development of this country. So looking at it that way, we see internationally and we see domestic legislation and we see adaptations around this matter in such a manner that legal imperatives are shifting the heavy duty on adaptive infrastructure, disaster risk minimization, and proactive hazard prevention. So it's no longer an option, it's becoming regulatory mandatory with explicit statutory duties to operationalize some of these adaptations and integrate some of these resilient mechanisms that are necessary, especially when you look at the new this legislation that's coming out, such as Kenya's Climate Change Act. That is something that we can see. I've already argued that when you look at the East African constitutions and when you look at the Kenyan constitution, for example, you'll see that the landscape around East Kenya, for example, under Article 42 of the Constitution and Article 39 of the Uganda Constitution, these frameworks are beginning to grant immediate locus standi to litigants seeking systematic climate accountability. So the issue of whether one had suffered damage or injury to be able to bring a case, that has collapsed around the transformative nature of the constitution we are seeing. The Ugandan constitution, as early as 1995, was that forward-looking by implementing the public trust doctrine around natural resources such as wetlands and so on. So these are issues that we can see. The Kenyan constitution arriving in 2010 is fortifying some of these provisions, and we see the right to clean and healthy environment coming through. Then we see entrenchment of the intergenerational equity issues post the Oposa case in the Philippines, post the progressive nature of the environmental legislation and policy that has come into place. Essentially, what we are seeing is that there's increasing accountability by requiring this generation to hold in trust this environment for future populations. And this, of course, we have seen it later on as linking us back to the various litigation that I'll be mentioning. So when we look at it from a constitutional perspective, both the Kenyan constitution, the Ugandan constitution, especially the objectives of the Ugandan constitution around issues of public trust, come in fairly handy. Now, when you see the introduction of administrative aspects such as the Environmental Management and Coordination Act in Kenya, establishing arms such as the tribunal, arms such as the NEMA, the National Environmental Management Authority, these authorities are coming in to review or indeed to bring about some judicial review metrics to expose regulatory failures, a lack of oversight, and procedural error. So eventually, what we are seeing is that as NEMA is enforcing this procedural mechanism, Kenyans or citizens are also free to bring about administrative judicial review type of litigation in order to address what may be seen as the failure of statutory duty, or what can also be called the sovereign inaction, suing state agencies such as NEMA, for example, for failing to actively anticipate, prevent, or minimize the impacts of climate change as mandated by the Local Environmental Act, so that there is enough litigation, enough action that is being generated, as we'll see later in some of the cases, around issues of statutory failure of statutory duty, and whether also procedural impropriety and consultation failure happens, particularly when you look at the Kenyan Constitution under Article 10 and the requirement for environmental impact assessment and for public participation. Any failure around those issues actually generate or lead to litigation and action, or even if there's an error of law or irrelevant considerations, so that litigating licensing approvals granted to carbon-intensive developments because regulations completely ignored the climate resilience commitments in local legislation. These are things that we're beginning to see. So we're beginning to see major action at major points, either in the High Court, the Environment and Land Courts, and going all the way to the Supreme Court, as we shall see in at least one or two cases that I'm going to refer to. So when we look at this issue and we look at government liability and we ask whether states are liable, and we are saying yes, where is the evidence that we are drawing? We are drawing to positive legislation that is coming through. When you look at Chapter 5 of the Kenyan Constitution on Environment and Land, when you look at the principles there, they are fairly futuristic. They are fairly current in terms of how they ensure issues of intergenerational equity, issues of right to clean health and right to clean environment are being assured. Indeed, when you look at the trends that are coming through, there are some cases that have become really a good spotlight. For example, the Lake Baringo flooding case, where Kituo cha Sheria and some members of the community there sued the government in the Ichamos and the Tugen communities, essentially, who were displaced by flooding in this particular area, contend that the state failed its duties under the Climate Change Act 2016. And therefore, it failed to establish, this case establishes a major milestone towards demanding that state compensation for climate-induced loss and damage be something that one needs to, be alive to. So state parties or states are no longer in East Africa with their transformational constitutions. They are no longer sitting pretty by wanting to claim sovereign immunity. They can't afford that claim, because the litigation and the precedent that's coming through has shown that this is something that is now being actively litigated. Some of you will remember the issue of coal mining in Lamu, where the government had actually issued contracts, and there was going to be this project that was seen to be using coal, and for that reason, generating a lot of issues around environmental safety and so on. At the end of it, this project was revoked, and the fact that NEMA, the National Environmental Management Authority, had completely failed to assess the project was brought out in a manner that conflicted with what the National Climate Act would say. There are other groups, such as the regional groups, challenging the transboundary pipeline before the East African Court of Justice, seeking compliance with regional integration treaties. And the famous Owino Uhuru ruling, where the Supreme Court of Kenya awarded, made an award holding NEMA strictly liable for administrative neglect. This paves and has paved the path for civil climate-related toxic tort actions. I've just said that this is an area of litigation for which we all have to be conscious of. And then as people that have been in this space, we are required to be able to ensure that some of these aspects of jurisprudence come through for us. What can we do? What are the implications of some of these issues for us who are practicing, for us who are lawyers? It simply means, and I can see that my time has run out, so what I'll do is to push myself a bit faster. It simply means that we need to be conscious as practitioners on this side, or as defenders of government on that side, or indeed as environmental activists, that they are no longer, some of these defenses are no longer available like acts of God. There is now necessary mandatory climate risk integration, and public interest litigation pathways have since been established. So we cannot use acts of God. neither can we, excuse non-compliance by public bodies. And therefore, it calls that for us, we should be able to advise where we can. One of the things that I would like to say, which is critical for this kind of gathering, is that we who are involved in contracts and drafting of contracts, we need to rethink how we do things. We must move away from our archaic boilerplate contractual terms to ensuring that we protect public institutions, or we assist public institutions and state agencies to ensure that they adhere to climate change aspects of litigation, or aspects that will help them avoid litigation, so that the issues of liability and regulatory compliance are issues that we must deal with. So what have I said in a nutshell? That yes, we have seen growing trends in holding governments in this region to account. We have seen governments and the people of these regions adopting constitutions that are progressive. And in these constitutions, we've seen roles of government changing from just enforcers to now holders of public resources in trust. We have seen the rights such as right to clean and healthy environment entrenched in the Kenyan constitution. Indeed, we have seen the judiciary increasingly holding government to account, particularly in Kenya and Tanzania, as well as in Uganda. And the effect of it is that we are coming of age on matters of environmental litigation, and that what then states need to do is to know that this liability is real. What we need to do as practitioners is to know that this area of practice is expanding, and therefore we need to prepare ourselves, and that we need to continue the litigation in order to grow the jurisprudence around these issues. I want to thank you for listening to me, and hope that we can expand these conversations later. Mine was to cover this liability, to cover the human rights instruments available, and to make a case for what is emerging and what is likely to be the future trends in this area. The area of practice as we go forward is this one. I started with a story about these clients of mine. I'm on the way to High Court to appeal against that, but I'm also on my way to the Environment and Land Court to now bring about a serious petition around the issues of environmental pollution and injury to people's health in this area. So the battle is on. Join me in fighting the battle, even through your prayers. Thank you very much, and back to you, Mr. Manyara.
Thank you for the wonderful quality presentation, Dr. Olo. I think that was a top level presentation. If we were to clap for you, I think the audience would have already clapped and stamped their feet. So thank you for that. And I think it is also my humble duty to welcome the next speaker, Dr. Anje Doreen Irakoze, who is a partner and the head of the mining sector at Hubeya and Company Advocates, which is a leading law firm in Burundi, and a member of the DLA Piper Africa, and also a member of the Burundi Bar Association, and of course the East Africa Law Society. She advises on natural resources governance, energy transitions, and critical and strategic minerals, infrastructure, cross-border commercial matters across regional economic communities, including EAC and COMESA, which are practice areas increasingly intersecting with environmental liability and climate-related risks. I'm not going to speak so much into her trophies and awards, but allow me to also inform you that she sits in the board of directors of the Center for Development and Enterprise, Great Lakes. So with that said, allow me to introduce Dr. Irakoze to make her brief remark, and as we also take notes and learn. Question and answer will come later, please. Dr. Irakoze, please use your 15 minutes.
Thank you, moderator, for your kind introduction. Could you please help me to share the slides?
I am doing that just now.
Okay, okay. So, good afternoon, colleagues. I think the first speaker covered enough about state responsibilities, and I've been asked to cover corporate obligations. And if it pleases to everyone, I'm going to put my camera off because my internet is not good. So bear with me, but you'll be following my voice, and also the presentation will surface for this session. Moderator, can you please put it in sharing PowerPoint?
Sure, let me try that.
Okay. Okay.
Is it that way?
No.
Go the slideshow. Go to slideshow.
Uh-huh.
Then from the beginning. From the beginning. No, yeah, that one. Yeah.
Ah, thank you.
Perfect. Yeah.
Perfect. Okay, thank you. So over the next 15 minutes, I'm going to unpack what businesses in East Africa are now actually required to report on, and trace some international standards that are shaping our market, and show how greenwashing risk is hiding. And towards the end, I'm going to also share some opportunities for lawyers. So let me start by setting the stage with why this matters now. So the central point is this one. Climate is no longer a corporate social responsibility as we've seen it earlier in previous years. So it has become a financial governance and liability issue that reasonably investors, regulators, and increasingly, as we've heard from our previous speaker, courts now expect to see some movement and development. So let me outline 3 kinds of risk that we are corporate are likely to face. So there is a physical risk that we have drugs, flood, and extreme weather that directly hit assets, supply chains, and cash flows. So these are the impacts we can already see and feel in our jurisdictions. Now, consider transition risk as policy shifts, as carbon gets priced, and as technology and markets change, assets can be valued and put in prices. So in other words, the very act of moving towards a greener economy carries its own financial exposure. And thirdly, the one closest to our legal profession is the liability risk. Here, litigation now reaches corporate actors directly, and as a result, we've already seen project licenses challenged on climate grounds. So disclosure has moved from voluntary to mandatory, and that shift changes everything, because once reporting is statutory duty, what a company says, and just as importantly, what it fails to say about climate becomes legally consequential. So how did we arrive at this point? Next slide, please. Next, moderator, please. Okay, understanding the genesis helps us understand why the legal obligation, particularly the duty to report, is now so firm. Can you please move to the next slide?
The cursor. Are you able to use the cursor, Mr. Moderator?
Yes, I'm trying. I just have some technological impediment, but a few moments. You can proceed as I said that.
Perfect. So it began in the early 2000s with voluntary pioneer bodies like the Carbon Disclosure Project and the Global Reporting Initiative, which made the first real attempt to collect comparable corporate climate data entirely on a basis of a voluntary basis. So then came the turning point between 2015 and 2017, where in the wake of the Paris Agreement, the Financial Stability Board created the Task Force on Climate-Related Financial Disclosures. And that gave us the 4-pillar framework we still use today, including governance, strategy, risk management, metrics, and targets. Now, building on that foundation, between 2021 and 2023, the International Financial Reporting Standards Foundation established the National Sustainability Standard Board and issued the IFRS sustainability, taking those task force on climate-related financial disclosures pillars and turning them into a globally comparable baseline. All of this brings us to now. So the regulators drew what that voluntary principles-based reporting simply was not enough. So they began treating climate as a material risk, which means non-disclosure is no longer a gap, it's a governance and fiduciary breach. From here, we can draw two rationales. The classic securities law case about correcting mispricing and information asymmetry, and the broader net zero imperative. So importantly, those standards did not develop in isolation. And we are going to see how in this current slide. In the next slide, please. So to begin with, yes, thank you. To begin with, we have the global baseline, the International Sustainability Standards Board, through its standards, the International Financial Reporting Standards. So this is the global baseline built directly on the 4 pillars of the TCFD, the Task Force on Climate-Related Financial Disclosures. And sustainability too requires disclosure of climate risks and opportunities affecting cash flows and the cost of capital across the short, medium, and long term. So I've highlighted this because this is the standard East Africa is actually adopting. So now turning to the second, this is the European Union's CSRD, the Corporate Sustainability Reporting Directive, and it's accompanying the European Sustainability Reporting Standards. This introduced the important concept, no, we are still on the previous slide. This introduced the important concept of double materiality. And here's what that means. So companies disclose not only how climate affects the business, but how the business affects climate and society. Which brings me to the third, the United States. And here, can you please go back to the previous slide? Yes. So here the picture is far more fragmented with federal rules rolled back towards the older 2010 guidance. So it's state law that now leads. Now, before we move on the next slide, I want you to look at the band along the bottom because it tells you why none of this is optional for an and exporting region like ours. So roughly 40% of the world economy will soon sit under climate disclosure rules. More than 11 jurisdictions have already written them into law. And because everything converges on that single TCFD baseline, the rules stay broadly aligned across borders. So to pull this together, the global tide is clearly moving in one direction. And that leaves us with this question: where does this, in terms of region, where does this leaves us in the East African community? So next slide, please. So the thing to understand is that the duty flows down through a series of layers from the global level, the normative framework, right down to the national laws. On this slide, on the left, you can see that flow. So at the very top, we have the international layer, the Paris Agreement, and the nationally determined contributions now are being reinforced by the 2025 International Court of Justice opinion, confirming binding state obligations. From there, it goes down into the regional layer, which is our East African community. We have the treaty, we have the East African Community Climate Change Policy, and the 2026, recently, the East African Community Development Strategy, which really pushes for green economy. And then it lands finally at the national and market level, whereby we have constitutional environmental rights, national climate change acts, and capital market and stock exchange environmental, social, and governance rules. Now, the panel on the right shows how that is actually being enforced in some partner states. I'm not going to highlight all the East African partner states, but some of them. We have Kenya. There you've got the Capital Market Authority, the Nairobi Securities Exchange Environmental, Social, and Governance Manual, and the Institute of Certified Public Accountants of Kenya Roadmap, with public interest entities becoming mandatory from 2027. So in fact, here in Kenya's public interest entities entered their very first mandatory reporting cycle this past January this year, and large enterprises are expected to comply by 2028. To give you a sense of what that looks like in practice, so the Capital Market Authority requires those public interest entities to follow strict frameworks aligned with the Task Force on Climate-Related Financial Disclosures. And for listed insurers, the reporting cycles fall in both the International Sustainability Standard Board standards and the Nairobi Securities Exchange guidelines. Now, we have Tanzania, which is progressively moving through the Capital Market and Securities Authority and the National Board of Accountants and Auditors technical pronouncement, because they've adopted the International Sustainability Standard Boards from 2025. Here, to be specific, Tanzania actually introduced mandatory disclosure requirement back in January 2025. And then we also have Rwanda and Uganda that are moving forward. So the framework here is already set for some partner states. And the practical question that our client will be asking is, what specifically do our clients have to put in the report? Next slide, please. So here are 4 categories. The first is risks and opportunities. Under the International Sustainability Standard Board's climate standard, this is all about how physical risks like extreme weather and transition risks, like policy, technology, and market shifts, could affect cash flow strategy and the cost of capital. The second is the greenhouse gas emissions. So that is direct and indirect emissions right across the full value chain of our corporate activities. And here I would like to flag scope 3 in particular. It's the hardest to measure, but the easiest to underreport, and yet very often it's the largest share of the total. The third category is governance and strategy. In other words, how the board oversees climate risk and how climate is woven into the overall business strategy and capital allocation. And then the fourth, under sustainability, one of the International Sustainability Standard Board's General Sustainability Standard is the broader sustainability metrics that includes targets, resilience, human capital, and the wider environmental impact. So with that, let's now turn to where the quote now stands briefly on the next slide. So if you look at these three together, first we have the International Court of Justice, which in July 2025 confirmed that states are legally bound to protect the climate system. Second, on our continent, the African Climate Platform and the Pan-African Lawyers Union have asked the African Court on Human and People's Rights to ground those duties in our African Charter, including duties owned in relation to multinationals. And third, the practical consequences include corporate exposure as Project Now, project licensing are challenged on the climate grounds. Now, where do liability hide? Next slide, please. Let me show you the 4 places that GAP usually hides. The first is vague net zero pledges, bold that includes bold targets with no interim milestone, no costed plan, leaning heavily on offset or technology that does not yet exist. The second is the selective disclosure, and this is the cherry picking the greenest figures and quietly omitting or underreporting scope number 3, which is exactly where the real footprint tends to sit. And the third is some claims like sustainable, carbon neutral, or green words that the company simply cannot defend once an assurer asks for the evidence. And the fourth, which is easy to miss, is the opaque carbon credit, folding offset into a single net figure instead of reporting credits separately, which hides gross emissions behind credit of uncertain quality. So each of these is a sentence in an annual report today, but it's a potential cause of action for tomorrow. So next slide, please. How should corporate integrate climate into governance document? Here I'm proposing a 4-step readiness path. First, they have to strengthen governance by naming board-level mandate for climate risk with clear lines of accountability at the very top. This is where it has to start. From there, they have to assess climate risk properly, by folding both physical and transition risk into company risk management and scenarios analysis rather than just treating them as a separate report, and then build the data and assurance by investing in a structured ESG data system that can actually withstand limited and eventually reasonable assurance. And finally, set measurable targets that are clear, costed, and reported consistently year on year so progress can be tracked. The panel here on the right slide, on this slide, captures the whole idea. So when climate sits inside governance system of a corporate, disclosure becomes a byproduct of how the business is generally run, and crucially, the company can then defend every single claim it makes. And this integration, in my view, is the single strongest defense against any greenwashing liability. So let me now turn the coin over. Yes, by now going through some of the opportunities, we can go to the next slide, please, for lawyers. So how do we lead as lawyers? But since we are on this slide, so let me give you 4 ways. Okay. Yes, please. So let me give you 4 ways disclosure becomes an advantage rather than a burden. First, access to green finance, including, is very important for corporate. Second, the critical minerals advantage within our region can convert this into investment where disclosure can withstand scrutiny. And the regional green taxonomy is also important. And fourth, we must not forget the just transition that is happening now. So based on that, who is positioned to lead it? How can lawyers lead these conversations or initiatives? So I'm proposing 4 ways. To begin with, we can advise on materiality by helping boards judge which climate risks are material and legally reportable. Next, we can counsel boards and executives by translating these disclosure duties into board agendas, into director accountability, into decisions that can actually be defended later. Third, we can manage liability. So here we can stress test the claims and the pledges before they are published, closing the very gap that greenwashing and climate litigation are designed to exploit. And finally, as lawyers, we can lead compliance readiness by building the roadmap now across governance, data assurance, and controls that our client meet the mandate calmly rather than scrambling at the deadline. So let me bring this all together. Next. First, climate disclosure is now a legal duty that is spreading right across East African communities, but also in our respective jurisdictions. Second, and very concretely, East African businesses must disclose their climate risks, their scope, emissions, and their governance and strategy, as we've seen it from the normative framework. And third, the courts are catching up very fast. And greenwashing is the live liability frontier where many companies are exposed without realizing it. And fourth, and I want to end on this note, disclosure is not only risk, it is a strategic advantage that allow corporates to access green finance, but also that places our regional minerals at an advantage level in this just transition development. Which brings me to my final point. Lawyers are the people best placed to lead this. First, on different frontiers, on materiality, on counseling boards, on managing liability and readiness. So thank you for your kind attention, and over to you, moderator.
Thank you, Daktari. It has been an insightful and highly technical presentation. I got caught up in technological mishap, and I apologize for that. Thank you, Mark. I have really learned a lot, and I honestly have a question for you at the right time. So, allow me to welcome the next speaker. I think we will go with Kefa. Allow me to introduce Kefa. I have made his profile. I wrote it down myself. Kefa Kutesa Nsubuga is an advocate of the courts of judicature in Uganda and the managing partner of Maples and Associates Advocates, where he leads the firm's energy, environment, and climate change practice, as well as its banking and finance work. He brings more than 14 years experience to the bar. He is a graduate of Makerere University and a diploma in legal practice from the Law Development Center. He is currently pursuing an LLM in environment and energy law at the University of Birmingham in the UK. He began his career in finance, but now he is advising the banks in the areas of investment funds and lending portfolios. Without going so much into his CV, which is very long, allow me and join me in welcoming Kefa Kutesa to give us his brief presentation on the topic of the day.
Thank you,
Karibu
Mr.
sana, Kefa.
Thank you, Mr. Manyara, for the warm introduction. I don't have slides, but we'll, lead my discussion from this other side. The topic that I was assigned is around climate risk in environmental impact assessment approvals, looking at the legal standards, approval conditions, and emerging grounds for challenging project licenses in East Africa. I'll try to look at the different regions within the East African community. I'll start by giving a background. I know many of you have heard about environmental impact assessments, but perhaps don't know some history around them. These have been around for half a century, and they now apply in most countries. And they're basically a crucial policy tool for obtaining and evaluating environmental information in developing decision-making, in the development decision-making process. And as we speak, it's in more than 190 countries that have introduced this form of environmental impact assessment system. And what are some of the characteristics of environmental impact assessments? We'll be looking at, they're aimed at preventing and minimizing harm to the environment. They are administrative processes consisting of several steps, and they normally begin in the planning phase prior to the activity taking place. They predict impacts of an activity on the environment. And finally, they provide evidence to determine trade-offs. Normally EIAs or environmental impact assessments are predicative administrative tools that generate data to weigh competing priorities. Here you'll find that while this EIA cannot make a final political decision, it will normally provide technical evidence that would be required to compare different pathways for given projects. Those who may not know, in the early 90s, these EIAs were generally required in all developing countries because development banks, the World Bank, the IMF, and so on and so forth, required these EIAs for projects that were considering finance. It was typically a response to funding requirements of development financial institutions. Although now development countries have gone on to have in place legislation around them. Of course, it hasn't changed yet. It's still one of those requirements that the development financial institutions will require. Procedures of EIA are generally similar, but the quality of application will normally vary depending on country. In Uganda, EIAs are formally established under our national law, the National Environment Act, and the regulations, and it gives great attention to social and other emerging issues. So I'll quickly run into how the environmental and climate considerations are being integrated into EIA approval processes. Of course, like I said, there are now EIA legislation that has been put in place by the different countries. And so you have the case of Kenya. I mean, Dr. Pondo has already mentioned there's a Climate Change Act there, which works alongside the Environment Management and Coordination Act that integrates climate risk and vulnerability assessments into EIAs across public and private sectors. In Uganda, I already mentioned the national law and the regulations. Similarly, it also puts in place, it puts a consideration for projects' vulnerability to climate change and its emissions footprint before issuing an approval certificate. This you'll find in Regulation 12 of the National Environment, in bracket Environmental and Social Assessment Regulations 2020. Tanzania is also similarly like all the others. It has a national law and regulations, and also demands that developers account for the green gas emissions and ecosystem resilience. By and large, having a similar outlook as the East African region. Of course, not forgetting the East African Climate Change Policy, which outlines transboundary standards designed to align national EIA review mechanisms for shared infrastructure projects such as pipelines, railways, and water bodies. Going further to the international level now, Dr. mentioned that 2 doctors mentioned on this. Recently in 2025, the International Court of Justice delivered a landmark advisory opinion on obligations of states in respect to climate change. The opinion provides authoritative legal guidance on states' obligations to address climate change and prevent significant harm to vulnerable countries and communities. In particular, when it comes to EIAs, the court made several observations about the necessary content of EIAs in the context of climate change. The most significant of this relates to EIAs for fossil fuel extraction projects. Until recent, the EIAs for such projects mostly focused on only emissions that occur in operating, say, an oil and gas field or coal mine. But as it stands, I mean, between 75% and 85% of greenhouse gas emissions associated with the oil production occur when the fuel is ultimately consumed, such as in a car or in an aircraft. Therefore, the court ruled that the end user emissions from burning extracted fossil fuels must be considered in EIAs for fossil fuel projects. Of course, now the focus is you're looking at what the Dr. Irakoze mentioned, the scope 3 emissions that will fall in this aspect. The the resultant use of some of these products. So that's the extent to which the International Court of Justice has come. And whereas the opinion is non-binding, it's clear that failure to act can trigger legal consequences. In addition, recently in May, the United Nations General Assembly also welcomed and endorsed this landmark climate ruling at its sitting, at the 41st sitting. So by and large, it reaffirmed that protecting climate from greenhouse gas emissions is a strict law obligation and not just a political choice. So by and large, you will find that climate change has started influencing, or climate considerations are being integrated into the EIA processes. I'll divulge briefly into the legal standards regulators normally apply in conditioning some of these project licenses. Ordinarily, the different laws I have stated give scenarios. For example, when you come to Uganda, Dr. Pondo mentioned it clearly, under our constitution, there's a right to a clean and healthy environment under Article 31. So that in effect requires that no project licensing infringes upon the public's right to a safe ecosystem. So by and large in Uganda, this process of EIAs is overseen by the National Management Authority, which issues certificates of approval. So the different projects that normally are mandated under the law that will require EIAs, and these are mostly large infrastructure projects, like you're talking of mining, industrial, manufacturing. I mean, some of you that have been following, we have the oil pipeline that is running from Uganda into Tanzania to get to Tanga. That is a huge one. And back then there were issues around the environmental impact assessment, which was challenged, but eventually was cleared. So some of those will fall there and will require to have the EIA provided. Basically, the process will look at screening and two processes. It's more, the first process is screening and the other is called scoping. Screening is where, they're first trying to determine if there is any issues that will lead to carrying out an EIA of a given project. Define evaluate the project and define the boundaries of the assessment. Once that is done and the assessment is done, and perhaps there's no need for a full EIA, then most of the time you'll have what you call a project brief that talks about the environmental aspects of the project and how they're going to be handled or addressed. So should it occur that the issues that require full EIA, then it will go into scoping. And under scoping is where now you draw down the scientific and social impacts of such a project, drawing out the terms of reference that will guide whoever is going to perform this particular EIA. And so you'll have issues, assessment of, say, issues like public consultation, which Dr. Pondo talked about, and we shall look at shortly as one of the reasons, or one of the procedural issues that would warrant a challenge in the courts of law. So once the scope has been done and it points rather, once the screening has done, it points to a full EIA, then the scoping takes place, defining the terms of reference, and then they'll proceed to do the EIA, leading to issuance of a report to the authorities, which report is reviewed. Where satisfactory, the certificate is given. Where not, these issues are pointed out, and the developer is required to address them to the satisfaction of the authorities before granting of the license. Then finally, you have the monitoring, where NEMA and the authorities will continuously follow up to ensure that the developer adheres to the mitigation measures that put across, so that these risks are well handled, but also the developer is held accountable in the process. So quickly, I'll look at the common procedure and substantive vulnerabilities in approvals that normally give rise to disputes and judicial review. I'll look at two in the interest of time. It has already been mentioned that a flawed public consultation in itself is a procedural issue, which will highly create a vulnerable state opposition for the regulators or authorities, or the developer fails to actively invite public comments, and they just rush on to do what they want to do. In such circumstances, that would be a procedural defect. Talking of flawed, it's something that looks like, but it's not. Where you perhaps you're just ticking a box and not concentrating on getting the actual participation of the people. So the other one is failure to hold a mandatory public hearing for high stakes controversial projects, where you totally omit without any extremely legally sound justification. This gives ground for judicial review, and we've seen this happen. There's a notable case here in Uganda where a civil society organization challenged the issuance of an EIA certificate to a sugar producer. And in gazetted parts of one of our forests in Uganda called Bugoma Central Forest Reserve for sugarcane growing. When they go to the court emphasized that developers and NEMA, which is our authority here, must ensure that EIA process is participatory. People should be able to participate. It's not a matter of ticking a box or having a crowd of people around and then ticking spot. It should be where they participate. So whereas the court, so the court emphasized that, and this decision cemented that that it's a standard when it comes to EIA that a genuine public participation should be seen to have been done, rather than treating local stakeholders and affected communities as a procedural formality. That would be for the procedure. And then when we go into the substantive, there I'll also look at two of them, where the conditions are ultra-vires. For example, NEMA, goes over and beyond their mandate, where the conditions have set out clearly fall outside their legal mandate, or if they arbitrarily intervene with lawful land usage without due process. So in such a way, in such instances, this is also challengeable in the courts of law. For example, there's also the other approvals in environmental sensitive areas. Approving projects within protected areas like permanent wetlands or forest reserve, like our case that I've shared here, without demonstrating an exceptional public interest case, creates a direct statutory violation, and in such circumstances, the authorities can be brought to book. And then the other one is totally failing to comply with the requirements, because the requirements are there for different projects. I mean, there's another case here in Uganda where, you know, the land owned, one of the parties owned land in a wetland and proceeded to build without the EIA certificate. NEMA issued a restoration order to hold the development, and the developer sued, claiming his property rights were being violated. And the court, ruling in favor of NEMA, declared that having a land title does not automatically allow a developer to bypass an environmental assessment or build in an ecologically sensitive area like a wetland. More importantly, the court officially integrated the precautionary principle and the polluter pays principle into the Ugandan jurisdiction. So, as I come to a close, what would be the considerations influencing infrastructure, energy, and extractive project approvals? I've already mentioned some previously, but just to make just one note that under the United Nations program, these infrastructure projects, you know, account roughly for 79% of global green gas emissions and 88% of all adaptation costs. Therefore, regulators no longer approve structure based solely on historical data. So there is that need to have new information. What is it today? It's no longer in the past, but what is it today? So there's a stricter environmental and social impact assessment on these extractive projects, like those who followed the case of this East African crude oil pipeline in Uganda going through Tanzania, where increasingly they were required to implement extensive mitigation strategies, and where possible come on offsetting to satisfy the laws in both countries, but also the environmental, social, and governance standards within the region, but also for their finances. So by and large, that is the standard. It's still as is, and it's a high one, and they need to developers, you know, are brought to book, are called to a higher standard to ensure that whatever projects that they're developing, you know, they have to ensure that they won't have a harm to the environment. But if so, there should be mitigation strategies in place to ensure that the environment is kept safe. And finally, Mr. Moderator, I'll look at the practical implications for lawyers advising developers, investors, and regulators. I just looked at two key issues. Under our law, there's criminal liability. So where, you know, a person goes, one where a person cannot transfer a certificate of approval of EIA without notification to the authority. Secondly, where someone fails to complete the certificate approval. Thirdly, where one undertakes consultations during, fails to undertake consultations during the environmental impact process, which I mentioned, the public participation. So in such, and also dealing with other lead agencies where perhaps a project cuts through different sectors, where that consultation is not done. If it's an individual and they're found, liable on conviction, the fine does not exceed 20,000 currency points, or imprisonment not exceeding 5 years, or both. And in case for corporate, it's a fine not exceeding 50,000 currency points. So here, perhaps the directors would, be left off the hook, and so it would be more of the organization to take, the flag by paying that 50,000 currency points. Here in Uganda, a currency point is equal to 2,000. It's equal to 20,000 Uganda shilling. So you can calculate how much this would come to. And then finally, the civil liability. Under our National Climate Change Act, the civil liability operates now through expanded provisions that allow individuals, civil society, and communities to hold both public and private entities legally accountable for failing to perform mandated climate duties. So in addition, failure to meet these standards I've mentioned of the EIA process would likely give rise to civil actions that will be filed in the courts by way of judicial reviews where, where procedural substantial matters were left out, or someone could file an entirely, a new claim against the different private entities or private. So by and large, as lawyers, we need to be aware of these liabilities. Like Dr. Pondo said, as we're advising in the contractual drafting, we need to be alive to these issues and see how much we can mitigate so that our clients are protected from this liability. I thank you so much, Mr. Moderator.
Thank you, Kefa. You've taken me back to a conversation I was having with a colleague about environmental impact assessment and why it is a ripe area for advocates actually to practice, because you are actually certified as an environmental impact assessment officer. Like in Kenya, there are so many buildings coming up, and there is a mandatory requirement that there must be an environmental impact assessment that must be done before these approvals are done. There is also the environmental social impact assessment, also a separate area. So thank you for the wonderful presentation. Allow me then now to invite, I think our next speaker will be Angela. Angela, are you there?
Yes, I am.
So allow me to introduce to you Angela. Angela is a seasoned lawyer. Angela Wairimu Kamau. Over 10 years experience at the intersection of land law, finance, and environmental law and policy. She brings deep practical and advisory expertise in complex regulatory and transactional matters. She holds a bachelor's degree from the University of Nairobi, master's degree in environmental law from the University of Cape Town, South Africa, and her work spans environmental and social due diligence, land governance, infrastructure, and project finance, in policy development, supporting corporate investors and public institutions in Kenya. She is keen about aligning legal framework, investment decisions, and development goals with climate resilience and social impact. She is also passionate about building capacity in ESG integration climate risk governance, and sustainable finance. So Angela is going to talk to us specifically about ESG, green finance, climate risk disclosures, and how the environmental and social due diligence is reshaping our corporate and investment decisions in the East Africa region. So, ladies and gentlemen, welcome, Angela. I will help by projecting her slide if she allows me.
Thank you, Mr. Mukua. I would ask to disable my camera because of low bandwidth issues, but I'm sure you will be able to hear me.
That's fine.
Please share the slides. But even as you're sharing the slides, I think the first thing that I would want us to all agree on and all understand is that there is a distinction between ESG and CSR. I think for most of us, we've usually had an understanding of CSR, but now we are moving towards a different principle and a different aspect. Which is what is called ESG, which is short for environment, social, and governance. And I think what has come out of these discussions on ESG is perhaps people assuming that it is good to have. It has become a buzzword. And yet, if you consider it strictly, this is not something new. As previous speakers have mentioned, we've always had a regulatory framework on environment. We've always had regulatory frameworks dealing with social and even governance issues. And in particular, if I give an example of Kenya, our governance framework has always been, has all along been guided by written laws and written guidelines, and for public institutions by the Mwongozo Code of Governance. So the whole principle of ESG is not new. It is just at the forefront now, and more or less we can say that it has grown what we usually knew as CSR. And if you think about CSR, the focus was probably on the E and the S, and the governance was left to the boardrooms to manage and ensure that it works well. So now ESG is central to how we conduct business, and you find that there has been a growing move towards adopting this as central to how businesses are conducted. I particularly taken back to 2021 when the Central Bank of Kenya issued guidelines to banks to start reporting on climate change related risks. I think it is not in doubt that there is a change that is being manifested within the climate. And even as the skeptics will always exist, it is true that the way we experience the climate now, or even the weather now, is not how we experienced it 20 years ago. So, and this then has implications on business. It has implications on how institutions manage their risks. And it is for that reason that the Central Bank of Kenya guided commercial banks in the country to start to include climate change risks in their risk management frameworks, and then in that regard to institute controls on the risks that they would have identified. And the risks are many and they are numerous. And we only need to look at the news items in all our East African countries to see that the environmental risks, for example, are numerous. So even and that again also goes into the into social and governance risks. We've seen issues of blatant disregard of the social contract that businesses have, and we have seen that what that results in is resistance from communities on proposed projects, be they private or public. So Mokwa, I'll let you know when to move to the slides. So we can just go to slide 2.
Okay.
So for social and governance issues, we have seen what bad decisions made in boardrooms have resulted in, and these bad decisions made in boardrooms cost money. They erode the trust that the citizens have in the systems, and eventually they ostracize these businesses and their entire being from our society. I'll give a very good example of what has happened recently with the fall of the Metropolitan Sacco in Kenya, where bad boardroom decisions have led to the collapse of a Sacco that had in its portfolio a huge number of teachers in the country, and the money was embezzled and misappropriated. Money was invested poorly, and eventually, when the institution collapsed, it has cost teachers their life savings, it has cost teachers their retirement benefits, and you can see that had they had good governance from the very beginning, then these were things that could have been averted. These were risks that could have been controlled before we got to where we are right now. So with regard to climate ESG and climate risk disclosures, I think I have given a brief introduction of what is currently happening, and perhaps as we go on, we will see how broadly this is coming about. Mokwa, if you could go to the next slide. So how is ESG embedded in legal and commercial due diligence? As it is right now, if you think of big projects, probably financed projects, for example, some of the things that you will be considering within the aspects of ESG are issues to do with land tenure, issues to do with resettlement, and issues to do with community rights. And with this particular bullet here, I would want you to think about the mining concessions that we have that are currently being granted, and I'm sure they're not only being granted in Kenya. I'm sure they're being granted across the East African region, and you'll find that most of these mining concessions are in areas where land is communally held. And what does it mean? Kenya, for example, has a Community Land Act. While we are getting ready or prospecting for these minerals, and while we are looking, we foresee the chance or the possibility of we foresee a possibility of resettlement. Are we taking into consideration the rights, or are we taking into consideration the responsibility we have towards these communities, whether they're registered or unregistered? So those are some of the issues that we consider, and I mean that is a clear social aspect of the ESG framework. Environmental permits and compliance history. Again, this has been touched on by KEFA, and what this basically means is that a program has been screened, and it's been screened for its impacts and how those impacts can be mitigated. Does this company do these businesses that are seeking to invest or entities that are seeking to borrow in financial institutions have a history of compliance, or do they just go and build on wetlands? So it's important to know the compliance history of these institutions, even as we are going into contracts with them. Again, also labor standards and supply chain risks. I think for the most, in most instances, you find that this is something that is usually taken very lightly. It's taken very lightly because people are looking for jobs, and this job is available, but there are labor standards that ought to be complied with to ensure that the welfare of the employees that are providing the services are properly taken care of. Again, also with supply chain, what are your sources of what are the sources of the materials that you are procuring? Who are these providers? Have they been debarred? When you think about supply chain, you think about not just whether the supplies or the sources are green, not just how they have been produced, which is a social aspect, but also the governance of those institutions. Have they complied with the regulatory framework that governs those suppliers? And again, as we have said, governance and internal controls, it is important that the strategies that are set or rather the policies that are set at boardroom level are such that are made towards the interest, to the best interest of the company and the investors and the beneficiaries. So what then happens when you're conducting this due diligence on those on the ESG aspects is that the findings may affect the deal valuation and even the structuring. It is possible that a deal can collapse because of poor ESG compliance. It is also possible that the controls that with ESG findings, you will see whether the controls that you have put in place, whether the way that you have planned to mitigate the risks that you have realized is actually effective. Are they effective? Will they end? And you see, you have to control with an objective. You have to know whether how are you controlling this to just reduce risk? Are you controlling this so that it saves you on money? What is the reason? What are your objectives for mitigating or accepting those risks, or controlling them in which way? The ESG findings will also affect the conditions precedent and post-closing obligations. Again, with we'll take an example of a big infrastructure contract. There will be demands that are placed by financiers, for example, to do certain things to comply or to bring them towards a safe zone for them for this contract to kick off. And then, of course, even when the project is closed, there will be post-closure obligations. And you can think of post-closure obligations as audits to confirm, to keep confirming or to continue monitoring whether you are still compliant, because it is a
Are you still there, Council?
Maybe reports at how they are reporting their EA.
We lost you for a moment, unless I'm alone.
Oh.
We lost you from, yes, maybe the last minute.
So I was saying it's important that whichever side you are on, whether as the investor or as the financier who's providing capital, that you have a checklist with which to gauge compliance, that you are also looking at the way the way these entities have reported on the various aspects. And with that checklist, you are able to check against your own risk framework far, how much risk you are able to take. So perhaps we could go to the next slide. So I think we've more or less covered this, but basically what we are saying is that there are considerations for either side, whether as investors or whether as lenders. And if say we are looking at construction of a road, for example, how is this project resilient against climate change risks? How is it? How will it fare in the event of shocks? In the event of extreme weather that we have all witnessed in our various countries. Again, also we also want to look at the transition risks, and transition risks happen when we have changing regulations. As it is right now, we have new carbon market regulations. They change the way we were. They changed the way we were reporting on offsets. They changed the way we were, accruing credits. So those kinds of changes are important to look into, and these are the things that we will be, as lawyers, we will be doing in terms of due diligence, or in terms of advising our clients on ESG compliance. So again, what is the risk that would come up if we do not take care of this kind of risks? High cost of capital, for example, and as it is, we all know that lenders rely a lot on they do a risk assessment of their clients to determine whether or not you are how good of a client you are, or how expensive of a facility you should be given. So there's also reduced access to finance. If you have a bad history, say for example, a bad governance history, you are not up to date with your filing returns, you're not up to date with your tax obligations, there's a lot of litigation on labor issues. For any lender, they look at you and they do not see a solid and credible client that they can they can work with. Next slide, please. So as we are proceeding, we really are still complying with the laws that have always been in place, whether it is the environmental laws or whether it is the corporate governance laws. We're still complying with that, but then we're looking far beyond that to ensure that we're not just reporting for reporting's sake. We are not just disclosing for compliance with guidelines. There is a larger benefit to disclose, because it builds trust. It builds the social contract between business and the citizens, business and the beneficiaries. So even the regulator is keen, even regulators are keen to see that there is a compliance, and there are active efforts that are being made by the regulated entities to not harm the environment, to take care of societal welfare, to enhance good governance in their institutions. And it's for that reason that there are lenders and investors and financial, regulators will be looking at the impacts, at the environmental and social impacts of the projects that are taken by business. They will be looking at, they will be keen to see how you have identified the climate risks that are attendant to the various projects, and the mitigation measures that have been put in place. So there's a need, there's a shift that we are going to see, and that we can already see from just reporting in one, or rather complying in transactions or transaction-based compliance, but continuous monitoring and reporting. And this is what regulators are asking for. These are the changes that are coming that have seen the stock exchanges require that all publicly listed companies are also reporting on this standard, on this standard. Same as accounting standards, they are also changing. So is banking, they're also changing. So there's a move to enhance reporting or enhance compliance with ESG frameworks from transactional to continuous, which then means that there's a gap that is created for capacity to be built in the areas of monitoring, so that even as a project is handed over to you, perhaps you are a lender, when a proposal comes to you, do you know what to look for? Do you know how to read these reports? Even as a client approaches you, how are you going to guide them how are you going to guide them towards reporting? And this is why we're saying that there's importance there. I mean, it's necessary for capacity to be built among us as lawyers, so that the beginning is we start from a place of knowledge as we are guiding our clients towards compliance. Next slide, please. So green financing frameworks are they're also coming up as new and innovative ways to raise capital, and we have seen this. We've seen this here in Kenya. I can give an example of the Safaricom Green Bond that was issued. I think it was last year or earlier this year. There was also the Kenya Mortgage Refinance Company Sustainability Bond, and these are new ways that institutions have come up, have developed to raise capital when you want to diversify from traditional or the conservative kind of borrowing that we have all seen. So we also have dedicated products from financial institutions that are, and all of these types of facilities coming to, I mean, the intended objective is that they finance green projects, and the implications, the legal implications for this is that there is an eligibility criteria for you to meet, for you to say that you are issuing a green or a sustainability bond. There is also use of proceeds restrictions, and that's what I'm saying. The intended objective must not be anything other than a project that is climate friendly, or a project that aims to mitigate or adapt towards the impacts of climate change. There will also, throughout those facilities, you will expect that there will be reporting, there will be verification and compliance obligations with set rules, or rather with ESG rules. So if there is inadequate ESG compliance in the setup of these facilities, there is likely to be regulatory and enforcement risk. There's likely to be reputational damage. You do not want to be known as a company that is unfair to its employees, that is not closes its eyes to pollutants or to polluting entities, that is that has a weak governance framework. And of course, one of the things that is expected is litigation and project delays, because when you have stepped on toes, there's likely to be backlash, and the backlash would be injunctions, which then leads, it affects project completion and attainment of internal objectives, much as they were not, or even loss making, much as it was the intention of the investor to achieve the absolute opposite. Next slide, please. So what is the role of lawyers? In this slide, I have broken the role of lawyers in two, for in-house counsel and for external counsel. And in-house counsel have the ultimate job to embed ESG and climate risk into corporate governance and strategy. It is in-house lawyers who ensure compliance. They're the ones who have a checklist before instructions are taken to external counsel. They're the ones who have gone through a checklist internally to confirm whether this is a risk they're willing to take, this is a risk they can mitigate, this is a risk that they can address in whichever way. So it's important that in-house counsel play a central role towards integrating ESG in corporate strategy. They're the ones that advise boards and management on regulatory exposure. So there's a significant role that is played by in-house counsel before then say, for example, instructions are issued to external counsel. And once they are issued to external counsel, it is the work of the external counsel to again confirm, undertake that ESG focused due diligence for transactions. And it would be important at this stage to also include other professions. What is the risk when you want to put up a 20 floor tower here? What does that? What is the risk of this of putting it here? Are you able to say? Are you able to say that authoritatively? Would it help to work with other professionals, be they surveyors, be they engineers, who can assess the soil integrity, the ground integrity, who would probably even have knowledge of the history of this place and its suitability for the intended project, so that even as you're reporting to in-house counsel or as you're reporting to a lender, for example, then you are saying you're helping in the risk mitigation process. So you also advise on regulatory approvals, and this is necessary even for us, for external counsel, as they are receiving clients, these investors, as they intend to put up these major developments. How have they complied with the regulatory framework? What is their governance strategy? What is their governance framework? Are they properly constituted? Are they well before the company's regulations, their tax obligations? How well are they? Even then, when you are putting up, or rather, when you're bringing projects within communities, how have you involved them without just appearing to, without checking a box or without copy pasting EIA reports? How well are they involved? Because if they're not involved, it will show. As the project goes on, it will show. And we say that stakeholder engagement is continuous. You have to work with them beginning through implementation through to closure. It is important that they are continuously involved to also enhance acceptance. Again, also, when structuring these green facilities, these green finance facilities, as you're drafting these contracts, as you're drafting even contracts, even if they're not just green finance transactions, but basically, all in all, as you're drafting contracts, it's important that you keep an eye out for things that may be risky towards this project. So it's also important that you also client to develop develop a risk assessment for this particular project, so that when you need to draft the clauses on warranties, the clauses of indemnities, then you know what kind of risk you're guiding your client towards taking, or perhaps guide them towards making an alternative decision that may involve a cancellation of that deal. And of course, ensure that you are always paid. That's the S in the ESG. Support, you know, we also, as external counsel, it is also the role of external counsel to support in policy development, so that when our law societies send to us proposed policies, we participate in these policy processes. We can, you know, we can work with policymakers to even develop policies within this context. So there are opportunities for lawyers to play, and I think this is a good place to end, knowing that there are, you know, many ways to put food on our tables. Thank you very much.
Thank you, Angela. ESG is a very, very emerging area in legal practice, particularly with the way in which we're moving away from voluntary reporting to mandatory reporting requirements, particularly for the listed companies. And your presentation has actually been very, very accurate, apt, and we thank you for that. It could not have come at a better time. So before we go to the Q&A session, I would wish to invite two last speakers, that is Mr. Mulama and Mr. Ball. We'll start with Mr. Mulama, whom I will give a brief introduction about before we do Mr. Ball. I believe he's on the platform. Mr. Mulama is an advocate of the High Court of Kenya and the head of the legal department and local representative of the African Group of Negotiator Expert Support, that is AGNES. He holds a bachelor's law from JKUAT and has always risen through the ranks of the organization from legal officer to leading its entire legal department. So for those of you who do not know what AGNES is, AGNES exists to give Africa one clear and credible voice in global climate diplomacy, furnishing scientific expertise and evidence to inform a common African position within the UNFCCC framework, and training the negotiators and climate leaders who carry that position to the world stage. So I think I have just given a brief introduction of who Mr. Mulama is. So help me welcome Mr. Leon Mulama to give his brief presentation before we call on Mr. Ball. I hope you are on the platform now. Then we will welcome the Q&A session. Let's keep it brief so that the members do not forget their questions.
Yeah. Yeah, thank you once again, Mr. Manyaro. Kindly confirm if you can hear me.
I can hear you, sir.
Perfect.
I've been waiting for someone to make a presentation in Kiswahili. It looks like East Africa, we are still under colonized, but ni sawa tu.
Nitaongeza kidogo. But allow me to structure the presentation into three broad areas of discussion. The first one is the types, categories, and approaches of climate change litigation claims. The second is around the emerging climate change litigation risks. And then the final one would be around the evolving role of courts in accountability, particularly in the East African region. Before I begin, allow me to set the scene on why I believe that we do have this growing wave of climate litigation. So initially we had this notion that climate change negotiations are a party-driven affair, and this is true. This essentially means that it is the executive that is responsible for climate change negotiations, for climate change adopting of some of these decisions that we agree at the COPs under the UNFCCC, implementing some of these decisions at the national level, and then reviewing these decisions when time arises. As in this case, when we're talking of the nationally determined contributions, it's every 5 years. But then as we progressed, it became apparent that the executive cannot be the only institution or entity that can drive climate action, both at the international level, nor at the national or subnational level. It became apparent that we need more stakeholders in the game. And this is where the whole notion of whole of society and whole of government approach arose. And so the whole of society approach just entails that we need to take into consideration relevant stakeholders whenever we are undertaking any climate change processes. And one principle that emerged from this whole of society approach is the principle of subsidiarity, which means that decisions or actions in climate change need to be done at the lowest administrative level as possible. And then we have this whole of government approach, which brings us to the core of this discussion. So essentially, the executive was undertaking its work, but then it became important that other arms of government contribute to the fight against climate change. So initially, it started by expanding the scope within the executive from the environment into the agriculture, where in 2009, just here in Nairobi, AMCEN, the African Ministerial Conference on Environment, adopted a decision which had been recommended by African negotiators, which essentially elevated agriculture to the level where we need to discuss it in climate change matters. And it is through this we are able to have emerging concepts such as climate smart agriculture. And then it also further expanded into the gender, where we now have these emerging concepts of gender responsive climate action. But it didn't stop there. It became apparent that we also need the legislature to make laws, to represent their people at the floor of the House or when having debates, and finally to oversee government climate change action. And then another vital role another arm that emerged as a key player was the judiciary, which interpreted some of these laws and issued to a level of, I would say, administrative review of our government climate change actions. Now we can move into the types of climate litigation cases. So there are 3 types of climate litigation cases. And the first one I would like to start with is public interest litigation. And this can be done in 2 ways. The first one is on constitutional petitions. And this is where you find a petitioner has brought an issue, a matter before the court, stipulating that there is a breach of the constitutional provisions which a country has. And in Kenya, it is typically done through the High Court. However, we also have a specialized court, which is the ELC court, which is responsible for handling environment and land matters. And then the second area we have is the class action suits. And this is one area which Dr. Martin Opondo had alluded to in his submission, where some of these civil tortious or claims have emerged or have grown to an extent where they become class action suits. In the essence, where there are multiple victims and there are various people who need to be held accountable. In the second area, which is not as prominent as we think or as it is expected to be, is around criminal offenses, which is criminal suits or prosecutions brought under climate change. Now, offenses in climate change are very subjective. They depend entirely on the provisions or the laws that the country has in relating to that offense. So you can find, for example, in Kenya or Uganda, which have standalone climate change legislations, that there are some offenses which emerge due to emerging due to non-compliance with the provisions of the legislation. An example I can provide is, if you look at the Kenyan Climate Change Act of 2016, you will find that if the Climate Change Directorate requests or issues you requesting information on a particular issue or a particular project that you're running, and you fail to do that, then you are in contravention of the act, and that becomes an offense which attracts penalties. Another example is where there are those authorized officers. In Kenya, there are the NEMA officers. In Uganda, I believe there are also the NEMA officers, where they have an authority to enter, investigate, and investigate a premises or a location to ascertain whether the climate change provisions are being adhered to. and to an instance where you deny them that entry or restrict their entry without due cause, then you are in contravention of the Climate Change Act, and in so doing, you have committed an offense. And then, of course, that is the climate. The third one is the civil litigations, or which are normally instituted through the nuisance tort, but some of them have emerged and grown to become class action suits, as aforementioned. And then we have these categories of climate change litigation claims. The first I would like to allude to is where you bring an action or a claim to hold a government officer, a government organ or state organ, or an individual responsible for their actions which contribute to climate change or are in contravention of the provisions that you have set out under your respective legal, policy, or international commitments. Then the second one, sorry, is around the procedural issues, where you find sometimes that a project proponent has overstepped or has missed an incredible procedure, for example, the environmental impact assessment, and they have already started undergoing their project or working on their project, but have not undertaken that essential environmental impact assessment. And I can give a case, for example, in 2025, we got a decision from Nakuru County, where the title is Menengai West shareholders versus the NEMA and Socian, if I'm not mistaken. So yeah, Socian Energy Limited. And what the decision essentially said was that EIAs, those environmental impact assessments, as Mr. Kefa was alluding to, have to be done before you even commence your project. So doing it while you've already started your project is in contravention of the procedures that we have set in place when undertaking our project in climate change environment. And it is very essential to note that if a climate change issue is not considered in an environmental impact assessment, then that environmental impact assessment is vulnerable to being quashed or set aside, and you will be ordered or a decision may be made that you need to undertake another EIA. And then the third one, of course, is on the human rights, which is basing its root around the right to clean and healthy environment, as well as other procedural rights, such as the right to a fair administrative action, a right to be heard, a freedom from discrimination, where in instances some people have been put aside or excluded from participating in some of these EIAs. And then finally, in the first broad area, I would like to discuss approaches to climate change litigation claims. The first approach I would take is constitutional, and this has very numerous areas that need to be discussed. So the first one, of course, is the human rights aspect. There are some, in our constitution, Kenya, Uganda, and other East African constitutions have tried to set aside or elevate the right to a clean and healthy environment to the point where you can institute proceedings if the government, if an entity, if an organization is failing or in its actions or contributions are endangering or leading to the breach of your right to a clean and healthy environment. Then the second one, of course, is the adherence to state obligations that have been set by the country. So for example, if I can use an example of the Constitution of Kenya, if you were to read Article 69(1), there are state obligations in relation to the environment, and some of these have environmental and climate change impacts. And then when you read Article 69(2), you will see that everyone in the country is required to collaborate with state organs to fulfill their respective obligations. And then, of course, it finds its basis under Article 70, which provides for the enforcement of environmental rights. Then the second broad area I wish to discuss is around the emerging risks, litigation risks that may come up when you are instituting a climate litigation case or claim. The first one is locus standi. Initially, this was a huge problem before. In the new would say, regime of environmental and climate change legislations, this has been addressed quite extensively, but before it used to be a very huge problem. And I can give an example. In 1989, Wangari Maathai, the famous Wangari Maathai, instituted a case proceeding against the Kenya Times, who were trying to build a conference center in the heart of Nairobi, which we currently call Uhuru Park. And the court simply just said, you do not have locus to bring this case before us. This has to be done by the Attorney General, who will then finally advance it to be discussed further by various entities. And this became a problem, and it was a very huge limitation to how individuals or other people would institute some of these climate litigation cases. And finally, we were able to get the EMCA 1999, which is the Environment Management and Coordination Act, which expanded our locus standi to where if there is a preemptive breach or an actual breach, then you're able to bring a matter before the court. And it has further been reaffirmed by the Constitution of Kenya under Article 70 and Article 22. And then the other area under locus standi is around the capacity to be sued. You'll find some instances. There's actually a petition that has been submitted in Kenya, I believe this year, where they want to take the National Climate Change Council and various other state actors to court, stating that they have not done enough to meet their climate change obligations, both internationally and nationally. And now one area which I would love to pose a question to you, and I'm sure we have some learned experts, including Dr. Martin here. How feasible is it to bring a matter before court suing against the National Climate Change Council, which is an unincorporated body, meaning it does not have any. It is not recognized as a natural or legal person in the Constitution of Kenya. However, an action has been brought before it. And you can see that this is another risk where there are some entities which may not be able to be sued based on their stature or their status within the country. And then the other area I would like to bring out, is around the compliance with procedural and legal requirements. There is a case in Uganda, which was a very good case. It was huge. It was something that was actually going to set a good precedence in the Ugandan jurisprudence, if I may say that, on climate change. And this was the Sama William and others versus the AG and others. And this was where the petitioner was saying that there needs to be, in accordance with the public trusts doctrine that had been alluded earlier, that the state needs to take more action when in relation to climate change. But then you'd find that the court actually dismissed the case simply because the petitioners were relying on public documents which were not certified by the Evidence Acts. And so you can see that a good case with a good potential to get a good precedence was set aside simply because the documents that were used were not certified under the Evidence Act. That's also another risk which we need to consider. We need to adhere to some of these procedural rules that we have either in the Civil Procedure Code or the Criminal Procedure Code to ensure that we are in alignment when we are submitting some of these climate litigation cases. And then the third area is around attribution science. And this is a very huge area. We still don't have a clear direction on how we can attribute some of these impacts you're feeling on climate change to a specific entity, organization, or country. You may find, for example, you may bring a case against an institution and they say, how sure are you that it is our emissions that went into the atmosphere and contributed directly to the impacts that you have suffered in relation to climate change? That is also a very pertinent area which we need to discuss and have a clear roadmap on as to how we engage or share or present such evidence before court to ensure that we are able to convince the court and the court is able to make an informed ruling. Outside the very few cases where the impact is directly attributable. For example, the case of the Owino Huru, which was alluded by Dr. Martin, it's outside that scope of area. It's very difficult for people to directly attribute that it is your emissions that led to these floods. It is your emissions that led to this drought. So they can always say that, no, it wasn't mine, it was China's, it was USA's, it was another country's, it was another entity's. And then the other area I need to also hammer home is the aspect of time. Under the East African Community Treaty, I believe Article 32, there is a time frame for instituting matters, which is about 2 months, for instituting matters that has been undertaken by party member states or EAC organs. And this time may be limited because imagine you have to now come through with some various evidences to support your filing. You have to come through with, you have to gather around some, outside the evidence, you need to gather around some witnesses, some victims, some, depends on the case rather, but you have to really get some of these important documents that you need to file within a very short time, which is the 2 months period. And so it is also something we need to consider, and it is a very huge risk when it comes to when submitting matters before the East African Court of Justice. And I'm seeing being told to finalize, and so I would just like to finalize by saying that the evolving role of courts has been instrumental, number one, because it has contributed to the interpretation of some of these ambiguous terms, ambiguous provisions. And I can give an example. If you were to look at the Kenyan MCA under sections 57A, and as read together with the Climate Change Act of 2016, section 23D, you will find that, yes, they speak about environmental impact assessments, but they do not explicitly mention that there needs to be a climate impact assessment. But the courts have interpreted these provisions to say that, yes, you need to have a specific climate impact assessment if the activity or project that you're going to undertake is going to contribute to climate change or advance or contribute to the emissions of GHG. And an example case I can give you is in 2023, we got a tribunal decision whereby the Green Belt movement were challenging NEMA and other actors, stating that these guys had not done an EIA which was inclusive or in compliance with the Climate Change Act. And in so doing, the court was able to interpret that, yes, if you're going to undertake an environmental and social impact assessment, then you need to have a very clear risk assessment of climate change. And that is why, even as to this day, if you're going to undertake an environmental impact assessment, there is always a specific chapter around climate change and how the measures that you're going to take to mitigate against contributing to climate change and its impacts. Allow me to stop here because of time, but yeah, we just as a call to action, there are various ways and mechanisms through which lawyers are able to contribute to this fight against climate change, particularly through the climate litigation.
Thank you, Mr. Mulama. You've really tried to compress a lot of quality information into a very short time frame, and we appreciate that. Thank you for giving us the different approaches on how we can approach the issues on climate change. And these are live things. These are things that are happening. Particularly, we have seen from other countries, from the ICJ, seen from the Netherlands, from the EU. Climate litigation is now very, very live. Even in Kenya, we have the Osman case from Isiolo. So I think Mr. Ball dropped. So we will end the presentations at that. They have been very, very lively. I wish to inform you that Dr. Irakoze has left, but if you have any personal questions that would require her attention, she has authorized me to share her personal email and contact. So I will post it on the chat. And now I will open the floor for the membership to raise their hands. The IT department will flag you if you have a question. If your question is directed to any specific panelist, please feel free to do that. I hope we can do this in the next 15 minutes so that we close. We were planning to end it at 4, but there has been too much wisdom flowing. So forgive me for that. Maybe as members are the public audience is getting up for questions. Maybe this is a general question to all the panelists. We are in the era of AI. What do you think, and this is a question you will answer as you answer the other questions, then what place do you think AI is going to play in climate governance, ESG, environmental governance, city planning, particularly because just now I have seen a message about someone from the city, a senior executive from the city county of Nairobi, having been arrested, having been found with over 2 million shillings in cash in the house. And he was the one in charge of city planning. And in the last few months, we've seen so many billboards and buildings collapsing, which means what we have been talking about environmental impact assessment probably was not properly done. So how do we relate these current events with technology and also our social ethics? How do we combine all these things to make the world a better place to live in, as well as also being mindful of our African traditions? Sometimes I tend to think that most of the theories and practices we're incorporating into our climate change infrastructure is foreign. So do you have theories that are more African than what we keep on discussing? But that's just a question. It can be an open question for discussion, but it can also be addressed. You can have your experiences. Members, you're allowed to raise your question so that they can be directed to a specific panelist. Hello, any question? Gabriel, do you have any comment, any question? If there is no question, maybe we can have the closing remarks from Gabriel Achai. Any question from the members? I cannot see the Q&A tab on the platform. I don't know. It's been a while since I last used Zoom. But if you have
was asked on the wall, we have responded to it, both Bwana Kutesa and myself, Bwana Kutesa and Zobwa and myself. So I believe that Duncan Odera if he's not satisfied, let him say so, but I think we've answered that. The rest, generally, I think there are comments about how the sessions were. So
Okay.
the people are okay.
Asante Daktari, and we hope to hear more wisdom from you. But I have particularly learned a lot about the need to redraft our contracts, because these force majeure clauses are no longer force majeure because climate risks can be foreseen.
Mr. Manyara,
Yeah, we better now begin. No, you asked a question. Let me now answer that, because there is increasing understanding that artificial intelligence is here to improve how things are. And depending on how artificial intelligence is programmed, issues of climate change, issues of mitigation can be anticipated better, can be predicted better, and can actually be quantified. Because really what you're saying is machine learning is something that can be conditioned, that modeling can be done, and issues to do with the legal governance, climate change, and so on are areas that the artificial intelligence machine learning can actually pick out and do better predictions. So even when it comes to quantifications now, we can get that better using AI and so on. So we can only say that things are going to be better. We need to work in that space ourselves and appreciate that the machine learning is here and that we can now use our knowledge to influence how those models are done. We don't just leave it to others to calibrate. We now need Africa-specific content to come through. What does it cost, for example, to annihilate our forests, our natural forests, our indigenous forests? And how do we compute that using AI and other technologies? So I think we can only say we have better days coming ahead of us, but let us localize. Let's bring content. Let's bring context to this discussion so that we don't rely on what outsiders tell us, but we also rely on our knowledge and what we bring to this conversation with our indigenous knowledge. Back to you.
Thank you, Daktari. I would welcome another perspective also alongside John Seka's question, that can we have an update on the EACOP case? Can someone say why the ESJ decided as it did in the first instance? I have not read that case myself, so allow me also to bounce the question back to the panelists, whoever is conversant with the case. Also, we continue pondering on Dr. Upondo's reaction to my question. I am fully a third world approach person, as opposed to welcoming all that is coming from the West. Maybe we can try and answer John Seka's question. Yes.
Mr. Manyara.
Yes, Kutesa.
Yes, I'm not going to answer Seka's question because I'm not up to date with that case. But just to add to what Dr. Martin Opondo has mentioned, yeah, I mean, AI in a way simplifies things and helps you get to sequence and model, get information, quicker and faster. But as I thought about it, I was looking at it as a double-edged sword, whereas it's going to help on simplifying, especially in the area of, creating the data, which is much needed. However, when you read around this very AI, there's been criticism around, these data centers that require quite a lot of water to cool and also using quite a lot of energy. So I guess at the end of the day is to see how do we balance, whereas we want to do this, but how do we balance to ensure that we attain what we want to do as we, combating climate change, but also, being responsible in a way using AI. Thank you.
Thank you. Thank you for that. Anyone who is familiar with the case?
Yeah, maybe I can take both Seka's questions.
Yes, please.
Yeah, so the first one, the EACOP, was because it was time-bound. It was time-barred. So essentially, they were saying the petition was filed in 2020. However, they say that this petition should have been filed as early as 2017. And this was further reaffirmed by the appellate division of the East Africa Court of Justice. And so that is why the time component of raising a matter becomes very important. So it was time barred under Article 32 of the East African Community Treaty. And then finally, it's on the PALU advisory opinion on climate change. One thing that I would really encourage you to do is to continue or to contribute to the Amici briefs that are being submitted under PALU. And this is because while this decision is an advisory opinion, it is going to set clear mandates around particularly 5 things which PALU have requested. That is the state obligations. The second one is climate change. And the third is human rights, which is going to be an additionality to what we already received from the ICJ and from ITLOS. And then we're also going to get an area around intergenerational equity, which is also another additionality to the current ICJ opinion. And then finally is around the disproportionate impact of climate change to vulnerable communities, which is also another additionality which we have not seen in the ICJ. But one way that I really encourage you to do is we only have about 9 countries as of last week, and then 4 additional countries which have requested an extension by 45 days to submit their own submissions. And what we need lawyers to do is to support or contribute to their country's submissions. We need it to be an African voice, yet we are seeing more representation or more submissions from global entities, from INGOs, as opposed to our own countries filing their own submissions, telling their stories to inform the court better on how to interpret the issues that have been raised. Yeah, over to you, Mr. Manyar.
Thank you for coming through. I was not aware of the case. It's a recent case. So thank you all for creating time to be part of this webinar. We have learned a lot. We have expanded our horizons, our perspectives. And thank you to the panelists for preparing and coming to share your knowledge with us. You know, you've gone to school, you've worked, gathered experience across this field. And it's always, we have to be grateful for you taking time to share your knowledge with us, because you took a lot of time to gather in it. And of course, also a lot of struggle. On my part, this is where I pen off. Thank you all for taking time to be with us, and see you some other day. May peace be with you. I now welcome Gabriel Achaya to close the meeting.
My brother Mokua, and also with you, may those fees follow you. May they be very timely. May they not come with the discount, but in their full measure on time. And to you all our participants and our dear esteemed panelists, it's really been a wonderful session. We hope we can have more and more and more of you in our subsequent sessions, and in particular at the 31st East Africa Law Society Conference that is happening this year in the beautiful island of Zanzibar. We hope to have a continuation of this discussion. And of course, we'll be sharing with you these slides and recordings on your different email addresses. But also, from the bottom of our hearts and on behalf of the entire leadership of the East Africa Law Society, we would like to express our sincere gratitude to you, Dr. Martin Olo, Mr. Kefa Kutesa, Mr. Leon Mulama, Ms. Angela Wairimu, Mr. Bol Dut in absentia, and Dr. Ange Doreen Irakoze for making time for this very wonderful webinar session. You know, such sessions are just more than sessions. Such sessions are sessions that inform policy briefs and advisory opinions that should be, shared out there to influence policy reform across the region, the continent, and even the globe. So we thank you all for this session, and we wish you all a very lovely afternoon ahead of you. We'll meet again here next week on Tuesday for another series of sessions that we have lined up for you. And in particular, if you're an insolvency practitioner, next week is your week, and we'll be discussing collapse across borders, navigating insolvency, asset recovery, and corporate restructuring in the East Africa jurisdiction. And if you're a public servant, we've not forgotten about you. We'll be discussing public servant or lawyer first, and we'll be looking at the ethical tensions, professional duties, and career consequences facing government and public sector lawyers in East Africa. For you who are in public sector practice, you really know the challenges that are faced when it comes to balancing either whether you're a lawyer or whether you are a public servant. So you don't want to miss that a wonderful session lined up next week. From us to you, we wish you a very lovely evening ahead, and you stay blessed until we certainly do meet again. Goodbye, and you can now exit the platform at leisure. Cheers.